A living trust is a document that consists of three main parties: the settlor, who has established the trust, the trustee, who manages the trust, and the beneficiaries who benefit from the trust. If it involves a married couple, a living trust will typically state that the trust assets go to the surviving spouse and then to their children when both pass. Now, for larger estates, there are A-B trusts, where Trust A transfers half of the assets to the surviving spouse. The other half goes into Trust B, and the surviving spouse gets the investment income from the B trust. When both die, Trust A and Trust B transfers to their heirs, doubling the amount that could be transferred estate tax-free. A living trust can provide three main benefits. Number one, avoid probate. Probate is the legal process of distributing property from one who has died onto others. During the process, the courts distribute the property to resolve claims. Now, most often, there are attorney's fees as well as court costs associated with taking a will through probate. And if one dies with or without a will, the estate still goes through probate. In addition, those who are able to receive the proceeds of a will are unable to receive these proceeds immediately, not until a probate court has approved the distribution. This process can tie the proceeds up from a few months to several years. If your heirs bring your will to a bank and attempt to withdraw money after your death, the bank will not allow them to touch the funds. The probate court must grant the bank permission. With a properly drafted living trust, on the other hand, that's a different story. Those who you name in the trust can generally go to the bank, bring a copy of your trust along with their identification and your death certificate, then they can withdraw funds immediately in accordance with the trust agreement. Number two, lawsuit protection. Whereas a living trust is not an asset protection device, it may give lawsuit protection to married people when assets are held between two trusts. Assets in a properly drafted trust for the wife can be insulated from the acts of the husband, for example. A lot of this depends on if you live in a community property state or not. We can, however, convert a living trust into an asset protection trust, which, especially if established offshore, is one of the strongest asset protection devices available. So a living trust can be turned into an asset protection trust as the need arises. Number three, sheltering your estate. You can shelter all or a large portion of your estate when you have conformed to sections 2056 and 2041 of the IRS tax code. Having property or money in a revocable trust does not require you to change your federal tax filing. It is analogous to you wearing a different colored hat. You simply file your taxes the same way you did before you had your trust. How to put property into a living trust. Number one, you can change the title to the property. For example, you can go to your bank and bring your trust document. Then you ask the banker to transfer your accounts into the trust. For real property, you can fill out a simple deed and transfer your real estate into the name of the trust. Or number two, you can list your property on a Schedule A. A Schedule A is a piece of paper that is usually attached to the back of the trust. If a property has title, such as a car or real estate, you change the title. Personal property is especially used on a Schedule A. It simply describes the property that you would like to have included in your trust. For example, the brown china cabinet, the red antique clock from Germany, my Hewlett-Packard printer model JJ54336. Each time you change a Schedule A, it is best to also have it notarized. Many people update their Schedule A's once a year or when they buy expensive items. It is often best to do both the above when possible. For example, as you can ask your banker to change the title to your bank account into the name of your trust. In addition, you can list Bank of America account number 005331242 on your Schedule A. This is an additional helpful guide to your heirs to your various bank and investment account. Revocable. You can modify your revocable living trust at any time. You can also be the trustee. You can be the initial beneficiary. The trustee is the one who manages the trust and holds legal title to the property in the trust for the benefits of another person or himself or herself in the case of most living trusts. The trustee is also required certain directions outlined in the trust document. That is, you can control the trust. You can change the beneficiaries as many times as you like. Again, the beneficiaries are the ones who receive the proceeds of the trust, typically upon your death. If you like, you can have another person or company act as your trustee. Somebody else can act as your trustee in the event of your inability to act as trustee. Per the trust document, they are generally required to perform the duties under your direction in the trust. You can also typically change who the trustee is at any time, and you can put money or property into your trust or take it out at will. Many people who have real estate holdings title each property in the name of a different land trust. Then they have a company who provides trustee services that they control stand in as trustee. A trust has a name that is not associated with the one who has the trust set up, for example. 123 Main Street Land Trust. So if anyone does a title in the public records, one's name who holds the beneficial interest in the property does not appear in the public records. Then all of these land trusts can funnel into one or more limited liability companies for lawsuit and asset protection, and then the living trust in turn owns the LLCs. Asset protection and estate planning. Owning a property in a revocable living trust does not provide you any more actual lawsuit protection than owning the same property in your own name. That is why many use living trusts in combination with asset protection devices. People hold title to their limited partnerships or LLCs in their trusts. For example, parents own 2% of the general partnership interest or management interest in the LLC in their living trust, and their children share the remaining 98% non-controlling interest in the companies. Again, a living trust does not provide asset protection from personal lawsuits. A properly structured limited partnership or LLC can. Then when you pass away, the managing party in that company, your general partner or your LLC management interest, can go to those whom you name, such as your children. And it does so without having to go through the expensive and time-consuming probate procedures. So we highly recommend that you review all trusts in detail with a knowledgeable estate planning specialist, and do so before implementing them into your estate and financial plan. Laws change and vary from time to time, and your specific needs may vary. You can call us at 1-888-444-4812. That's 1-888-444-4812, or complete the form on our website at companiesinc.com. Thank you.